Hey everyone, it's Rob Ryder. Today we're going to talk about property cards and classifications, such as the things that you would have at the local assessor's office, township, city, village. Legal fictions, concealing legal names, something they do all the time. The more you look, the more you see. It's like, hey, they're using something other than my legal name in a manner that has to do with my property or my liberty or whatever. And well, that's a deprivation of my rights under color of law. And they're in contempt of court because they're using a fictitious name. And the other thing it does, it clouds your title and fee and being real property tax free. Because the property cards and classifications have to do with figuring out your tax. And if they had titled your property to you properly and fee, I'll show you an example actually. Yeah, I can do that. I got one here. Let's look at this, right? That's what I'm talking about. This is the Schedule A to a title insurance policy. Every residential title insurance policy is going to have a Schedule A, is my belief, and a Schedule B. We want Schedule A. Name of the insured, right? This is a legal fiction, right? That isn't anybody's name. That's a legal fiction. That's who it was insured in. It was not insured in the name of Norman, Lou Gould, or Jillian Diane Gould, right? So they made up a legal fiction and replaced the husband and wife in their proper person names, and the legal fiction has it in fee simple. But it's not entitled to either of the individuals. It's entitled to a legal fiction. Now, was this legal fiction ever registered as a DBA? If it wasn't, then the creator of this is committing a misdemeanor every day for you by using it. But at the end of the day, to me, hey, this is title insurance fraud, right? This was done intentionally to conceal somebody's property from them and cloud the title and fee and keeping you from being real property tax free, right? So the state allows the use of a style of name other than the legal names in the form of apparently unregistered legal fictions. So, all right, they replace the full legal name, which it's either your given name and last name, or it's your first name, middle name, last name, depending on whose definition you use. But it's the name you're supposed to use in legal matters. And we're talking about the transfer of the title of property. Well, that to me is a legal matter, so you better be using my legal name. And they didn't do it. Title insurance fraud. File a claim. More on that later. So, legal name is the name that identifies a person for legal, administrative, and other official purposes. A person's first legal name generally is the name of the person was given for the purpose of registration of the birth, and which then appears on a birth certificate, see birth name, but may change subsequently. But if you're going to change it, you need to go to court and get a court order to change your name legally. Otherwise, then your legal name is the name that's on your birth certificate. Well, they don't use any frickin' initials on a birth certificate unless that's what they're using for a middle name or a first name. So to use it afterwards is not using your legal name. Your legal name is the name that's on your birth certificate. Right? So if you're not using your legal name, then it's a legal fiction. And legal fictions need to be registered as a DBA in the county, state, or the individuals using the legal fiction are committing a crime. The act in Michigan says if you don't register your DBA with the county, you're committing a misdemeanor every day that you're open for business. So every day you wake up, you just committed another misdemeanor by doing business in a name other than your full legal name. Which, as it turns out, really isn't so much as it is about the style of name, but the style in all caps isn't different than the style in proper case, because like in Latin, old Latin, Rome, they didn't have any little letters, so it all been in uppercase, right? So that's just but the style would be using a middle initial or a first initial or putting the last name first. something like that, right? But Robert Allen Ritlewski, when I say it, you can't tell if it was all caps or proper case or even lowercase. So that really isn't a style difference. That's a what type of noun difference, I guess. I'll leave it at that. But so your legal name is your first name, middle name, last name. Legal fictions, they need to be registered. So what I did is I went to the state of Michigan and I registered my name, Robert Allen Ritlewski, as my business. It's not a DBA. It's me doing business in my name. If I was going to do business as Robert A. Ritlewski, I would have to go do a DBA. But I never did. Yet one's being used for me already, right? So who created this dude with a middle initial? I didn't do it. But the state's allowing it to be used to represent me. So you are occasionally coerced or deceived into identifying yourself using an unregistered legal fiction on federal or state forms, causing the government subordination of perjury by its agents and attorneys. They're making you do it by giving you these forms that have in parentheses a style of name other than your full legal name. And you know what I'm talking about. Look at the form that says name, and then look at in parentheses or underneath the line, they'll have last name, first name, middle name, or something like that. Well, that's subordination of perjury. So, and in American law and Scots law, subordination of perjury is a crime of persuading a person to commit perjury, the swearing of a false oath to tell the truth in a legal proceeding, be it spoken or written. Okay, Rob Ryder. My email is courtofrecord@aol.com. No S's on the court or of or record, just courtofrecord@aol.com. My phone number is 616-712-6179. And if you are able and willing, I really do, I need you to donate. I can't pay my rent, and it's the October 1st. So I'm saying a little prayer. PayPal, they want you to use the email address, I guess that's associated to the business, and that would be robryder@aol.com. ROBBRYDER@aol.com. Or good old U.S. mail, Robert Allen Ritlewski, RYTLAWSKI, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341. And it's Sunday, October 1st, 2017. And speaking about U.S. mail, before I forget, you need to write first class mail below your stamp for it to be first class mail. I didn't know that until here recently when I read it in a manual, but yeah. And if it is first class mail, then they'll put a date stamp on that says when it was sent. It'll be on the envelope. I don't think they do that if you don't say it's first class mail. But if you look at some of the mail you get and it says first class, you look, it'll have a date stamp and when it was sent. You compare that to, not first class mail and see if it has the same date on there and so forth. So, yeah, you need to call it first class mail for it to be first class mail. All right. Before we go too far, if you watched my video last week, I had showed that for Yvonne, who had a traffic case, so they wrote in Michigan, it's called a uniform law citation, that resulted in another document being sent by the mail by the court called a notice of hearing, or is that what it is? Notice of appearance? Yeah, notice of appearance. From which the information that's on this form came from, right? So all this came off of the notice when she got a notice to appear. And it was for a motion, affidavit, and bench warrant. So we took the information. So on that, on the notice, it would have had the people of the state of Michigan, although that's probably incorrect. It should have been checked here and put state of Michigan, but whatever it said on the form. But they had her name backwards. See, this was the defendant's name on the notice to appear. Foster, Yvonne, or Elise. It's like, well, that's not her name. Right? Somebody has substituted a legal fiction for her name. And that's who they want her to be. So, having seen this, we put this in and said, well, okay, in this case, that is, this is the way you sent it to me. I request that the bench warrant be issued and Brian L. Mackey at this address be held in contempt for the following reasons, right? Using a false identity, prosecuting an alleged crime in an improper venue, by an authorized process, depriving rights in violation of 18 U.S.C. 242. And then I'm not going to read this whole thing because I did it in my last video at the beginning, so just watch the video just before this one. Have to do with filing a claim, and I went through the whole thing. But her case was, so she filed this into the court case, and her case was dismissed. Not only dismissed, she got a check. Where's that check at? 15th Judicial District for $200. She got her bond money back. They didn't keep any of it, right? She had to do a bond for $200, and they gave her all her bond money back, like it never happened, in her proper name with her address and so forth. So we're going to file a claim in the Court of Claims for her, like I had done for myself. In fact, hers may have gone in. I have to talk to her next week to see where we are with that, but that was good, right? That this, by simply saying that the attorney, right, because he's using a middle initial, just look at the paperwork. Well, that isn't his full legal name. We just saw it's the name on your birth certificate. Unless you got some other document, it's the name on your birth certificate. And Brian L. Mackey, I'm quite sure, is not on a birth certificate. Now, all he would have done to prove different is bring it in and say, well, here's my birth certificate. It's on there, Brian L. Mackey. But he didn't, and instead they dismissed the case. We said it was an improper venue also because there's a gold French flag in the courtroom, and that makes it a military tribunal, I believe, that we said that in hers. We said a lot of things in different people's paperwork recently, so I don't remember what it was in each one, but you get the idea. There you are. So because they do stuff like this, right, this is the state of Michigan that was supposed to have been bringing the claim, and they were using your name backwards, right, then I have a claim against the state of Michigan. And while this one, let me show you, is mine, it's what she would be doing. And so what I had done is I had gone to the Court of Claims and filed a claim, and again, this is in just the previous video to this, and they sent me a notification that they had received it. And I was the plaintiff, and the Department of Treasury was the defendant. The notice was in, blah, 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 blah. They gave it a notice number, tracking number. But I was upset because it didn't have the state of Michigan as the plaintiff, or as the defendant. It's like, well, how come they're not the defendant? That's who my claim was against, if you read it. Right? And that was this right here. Basically making the point that, hey, they're using a middle initial name to represent me, and it's clouding the title of my property. But as importantly, I wanted to point out that, who I was, not who I'm not, who I am. I am Robert Allen Lewski, the real party and interest of the Social Security account 374-506-794. All right, that's mine. And what's the other thing she told me? That they had redacted my Social Security number when it went to whoever it went to. And I'm going to have to call her back because I don't want her to do that. Right? I'm claiming that number. I want it on the paperwork. Okay, but this was basically against the state of Michigan, and they had only done it against Department of Treasury. And so I called them up and asked them, well, I wanted it against the state. And they said, well, I needed to file an amendment. And so I did, and this is my amendment that came back. And now it's state of Michigan et al. Well, that's more to my liking. Notification acknowledges the amendment notice of intent to file a claim received on September 28, 2017, naming the state of Michigan as the primary defendant, with the Department of Treasury being a secondary defendant. The amended notice has been processed and is hereby filed with the Court of Claims. Please note that your notice of intent previously filed and assigned tracking number 17-200255-o That is a little O. I asked her, what's that? Is that not a zero? What is that? It's a little O. Has been updated to reflect your amended notice. Robert Allen Radlewski, Defendant 1, State of Michigan. Defendant 2, Department of Treasury. Okay. And it was just simple as this. I, Robert Allen Radlewski, real party in interest to the damaged property described in the Notice of Intention to File a Claim in the Court of Claims filed on September 19, 2017 by the State of Michigan Court of Claims and assigned by said court tracking case number blah, 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 ask for an amendment to its notification of filing. It was my intention, State of Michigan, be the primary defendant in this matter. Received. There. Okay, hey, that's my public record, right? I like to do that. Okay, so I'm going to show you 4 different pieces of paper that go to the same transaction to show you that in all cases, they're using legal fictions to replace the identities of the man and woman, in this case, that were making a purchase of property. We already saw, right? It was in the name of the insured is, neither of these is either of their legal names, and altogether, it's nobody's legal name. It's just the name of a legal fiction. But maybe you could go and file a DBA and claim this name and say, well, that's my name, right? This name I'm doing business in, and do the DBA, and then you would have fee simple title because you claimed this name, right? Or say, well, the title insurance company did that on purpose, and that's title insurance fraud, and file a claim with the insurance company. If they won't do something about it, then go file a claim with the state insurance commissioner. And if he won't do something about it, well, then you take it to the court of claims, right? But you file a claim for the right reason, you might get a frickin' get a remedy. And the reason would be it was entitled to someone other than the people who paid to have it done, right? To a legal fiction, not to the man and woman. And it clouded their title. It's a unlawful conversion of their property. So I guess we should start with warranty deed. Let's go there. So here's a warranty deed, right? That's Norman L. Gould and Jillian D. Gould, husband and wife. Now this husband and wife is lowercase. That one's lowercase. There's no periods after the middle initials. All these little things to look at. Yeah, this one had a period, right? They put periods after this one. Does that make it different? Yeah, every jot and tittle mattered. That makes it different. Right? So the warranty deed doesn't match the title insurance. And the borrower, again, is another legal fiction. This time they put senior here. So, well, this doesn't match anything we've seen yet because neither of those had a senior in it. And then there was a satisfaction of mortgage, right? For a mortgage executed by, and this time it's in all caps, all caps, all caps, everything's in all caps. Right? So none of these legal fictions match each other, but they all represent the same 2 people. And how you undo that exactly, I don't know. So what Jillian is doing is she's gone and claimed all these frickin' legal fictions. And she's waiting for the paperwork to come back. And we're going to go put them into a court case and say, hey, I own all those names. That's my property. Right? Claim the legal fiction. But first you have to go and claim your proper name with the state so you can say you're doing business properly. Because if you're doing business in your name, you're a sole proprietor. Where there's no difference between the business or the individual. So you have to go and register your name. So again, on my last 4 or 5 videos, this is really the kind of stuff I've been talking about, and they get so long I can't really go over all the stuff again. They're just too damn long. But I'm going to leave it at that for a minute. I'm going to regroup for a second. Hang on. Okie dokie. So this next part really has to do specifically with Michigan, but I have to believe that something similar happens everywhere when it comes to um, how your property is handled for taxes, right? Because all property taxes, I believe, are local taxes, right? The only state tax really is sales tax. There's some use taxes like gas and so forth, but I believe all property taxes, even if it's collected by the state, is really for local use. But the state tax commission has some classifications, right? So these are all the different things that property can be classified for. Here's agricultural and commercial and industrial, and they got all these different subsets of industrial and commercial and so forth. Well, as it turns out, they have it for residential also. Now, as we're going to see, if we look at a property card, it's probably going to say it's a 401, residential improved. Right? It's residential, and real is the type of tax it is. But it was like, well, hey, they got a couple here for personal, not real. Right? So 451, residential personal, or residential leasehold improved, are both, which is 411, are both personal. And in Michigan, if it was personal tax, well, you wouldn't pay any tax. You only pay tax on real estate, on real taxes, on real property, excuse me, not on personal property. Right? So how do you get your property, which is probably a 401, to be a 451? I'm going to show you on the 401, right? So here's a property card. It would be at the local jurisdiction or piece of property, and here it is, class 401 residential. Well, I don't want 401. How do I make that 451? That would be something to find out. Why aren't you moving? All right. Now, here's the thing. See, this card here is on like a card stock, right? But they also had this style here. Here, this is grantee, grantor information is filled out, who's doing it, what the prices were, so forth, right? But on the same property, on this one, there's nothing in these boxes, right? This is where the grantee and the grantor should be, and book and page and so forth and so on. And, but it's the same house, it's the same lot, but none of this information on this style was filled out. But it is on this style. But this one, it's got these holes here. You can kind of see these holes. So this is the back side of that. No, this is the back side. Dot, dot, dot. And if we were to zoom in on this side, look way down here at the bottom, it says order by form number ML M293, revision 686, I believe, residential assessment record, printed on 20-pound bond paper, or 20-pound bond, also available on cardstock. Form approved by the State Tax Commission from Doubleday Brothers Company, Kalamazoo, Michigan. So if this had been, I believe this one's printed on bond paper. Here's the point. And the first one we looked at is printed on cardstock. And if it's printed on bond paper, well, it could be used as a bond, right? Could be a legal document because it's on bond paper, which is a type of security paper, because it has a watermark. If you control the watermark, well, you have some security over, that this is one of your documents and not somebody else's. So, right, because this information here is the information that should be on here, and there's nothing in here. So they didn't do, right, they never transferred the property legally, because this is the paper you'd make a legal transfer on bond paper. Use it for a contract. It's never been transferred to anybody. It's not even in a county, right? It just has a village. It doesn't say where it's located. It's not defined in a particular jurisdiction. No, nowhere on here does it say it's in Michigan. Right? So if it said blank county, like Kent County, and I think it's the village of Dryden, but that isn't where it is. There we go. County. Right? It's blank. Just a village named Dryden with some address, right? Well, that could be anywhere. Because this isn't a complete legal description. There's nothing legal about that. And they put this picture they put on here is over top of some paper or some other information because you can kind of see it's written in right here. It's like, well, what are they hiding below the picture? But they never transfer the property, according to this. And on this one, just because it said on here, it says it was classified 401 residential, which is really what we came to look at in the first place. Okay, well, let's get that changed then to 451 if we can. Right, and let's see what this said, 32. So these are just little blurbs and blobs about this particular subject. Where it said in here, agricultural and residential personal property are largely exempt from property taxation. See Exhibit 17. Agricultural and residential, they're all green. Apparently that means they're exempt because utility personal must be 100% taxable. Industrial is 40.5 and commercial 23.2. But if it's agricultural or residential, it's not taxed. So says the state of Michigan. All property classified as utility property is personal property. Utility real property is classified as industrial real property. In 2001, personal property accounted for 23.2% commercial taxable value, 40.5% industrial taxable value. Agricultural and residential personal property are largely exempt from property taxation. So, and then this one said property classification prepared by the Michigan State Tax Commission, right? So this is all from the state. They're the ones saying all this stuff. And there's something on this one. 15. It said residential personal property classification. What type of property is classified as residential personal property? For taxes levied before January 1st, 2003, residential personal property includes a home, cottage, or cabin on leased land, and a mobile home that would be accessible as real property under Section 2A, that the land on which it is located is not accessible because the land is exempt. Okay, that was before 2000. So before 2003, it included home, cottage, or cabin on leased land. Well, did it include home, cottage, and cabin on purchased land? It doesn't say. Are homes, cottages, and cabins on leased land to be classified as residential personal property? No. Something amended it and states that a home, cottage, or cabin on leased land are no longer residential personal property. For taxes levied after 2003, homes, cottages, and cabins on leased land are to be classified as residential real property. There was some tax thing going back in 2003 that had to do with how they were funding the schools, I believe, with the millage and so forth. This is also true of mobile homes that would be accessible as real property to the owner of the land as provided by MCL 211-2A, except the land on which the mobile home is exempt. Located as exempt. So it never really does say what property is classified as residential, but it used to include this and no longer does. So it doesn't include property, homes, cottages, or cabins on leased land. They're no longer residential personal property. Well, you would say, well, okay, that doesn't include me. I own it, so I'm going to say mine is personal property. I should be able to have that identifier and not pay taxes. And if you want to, take that approach, you're supposed to go to this March board, they call it, and petition the board of review. Right? And the undersigned protests the assessed value or the tentative taxable value or the property classification and or qualified agricultural property exemption of the following described property. Okay, but see, they want the owner's name. Well, we just saw they don't put your name in there, so the owner's name would be the name that's on the grantee on the warranty deed. Right? A legal fiction. They didn't put it in your name. Right? Petitioner's name if other than the owner. Well, that would be your name because they didn't use your name. Right? But to do that, you would have to own this name as a DBA. You'd say, okay, the owner's name is a DBA, put that in there. And then put your name, because you're the owner of the DBA, as the petitioner. Otherwise, if you try to fill this out with your name, it's like, well, that isn't who it is. And they may not tell you that is the reason they're not going to do it, but they're going to give some bullshit reason why they're not going to do it. I'm just saying, according to the way they're doing this stuff, you're not the owner because your name isn't on the warranty deed. It's not on the mortgage. It's not on the entitled to. It's not on anything. So you're not the owner. Now, see, none of this is explained anywhere, and this is a Michigan Department of Treasury form. So, hey, the state's involved. This is their form. Nevertheless, you want to challenge the classification. Protest the classification. Complete the section for request to change the classification. The Board of Review must make a decision regarding classification in accordance with this section here of some law, 211-34C. The Board of Review shall not be influenced by the effects. I believe I looked at this, and right, it gives a list of things that should be assessed, and yours wouldn't be by the classification that you could have because of this section of law here. Classification should be, so this is classification of property on this year's assessment roll. Residential 401. Classification it should be. See how they left this space here? I'd check a box here and I would write in residential 451. Or check the box here and put residential 451. But I put the number 451 and say right now it's residential 401. Not worried about that one. Reason for protest? Well, because I don't want to pay the tax I don't need to pay. I'm the owner. So if somebody has one in Michigan that, we could do one of these. I don't own any property, so I can't do this. But if you're watching from Michigan, well, you know what we're looking at. This is the idea. You're going to take this down to the township hall or whatever. Get your property records. Transfer some information on some forms and go file a complaint or file a petition. And see what they do. Or, if they don't want to do it, take it directly to the state for the state allowing all these fiction names to be put in place of your name so that you can't, you're not the owner. But if you did this and they didn't give you your remedy, then you're supposed to go to the Michigan Department of Treasury property owner petition for change of property classification, right? But you need to be the property owner. And you're not the property owner in your full legal name. It's in the name of a legal fiction. See, look at, they want you to fill it out. Now, this is where the subordination of perjury comes in. Property owner name, first, initial, and last. Name, attorney or agent information, first, initial, and last. Well, this is a legal matter. This is a petition for redress of wrongs. right? You're certifying stuff. Right? The undersigned completing this petition certifies to the best of his knowledge no information herein or attachment hereto is false and in any way, and all the information truly descriptive of the property for which the petition is submitted. Further, the undersigned is aware that any statement or information provided is untrue. The petition for change of property classification may be denied. Signature of property owner. Print or type name. Right? So, the name of the owner isn't your name. And you're going to sign and say that it is. You just committed perjury. You were coerced into it by this frickin' form that had, wants you to put your name with the middle initial. But that isn't the property owner. The property owner's name is on the deed of trust, and it's a fiction. Or the warranty deed. Or who's it entitled to, right? You would say, well, whoever it's entitled to is the owner. Well, that's on Schedule A of the title insurance, which is why you need to get a copy of your title insurance and tell them you want to look at Schedule A, see what name is on there, and that's a complaint all by itself, having nothing to do with the taxes, just the fact they didn't put it in your name. Because they're supposed to defend your title and fee, right, against all comers for any encumbrances. That's what you paid them for. And what they did is they put it in a legal fiction instead of putting it in your name. All right, hang on one more time. Okay, just a little more on this thing. So this is the form that you take to the petition to the Board of Review when you first notice that, hey, you made my stuff 401. I want it to be 451. So you want to petition the board to protest of classification. And the Board of Review must make their decision regarding classification in accordance with Section 211.34c of the Michigan Compiled Laws. And those laws say, here's 211.34c. It's on the third page in this one because it said C. I believe it said 3. Then go back and look. C. C, 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 C. And all this is C. And then it says the classification of assessable personal property are described as follows. So these following personal properties are assessable for taxes, which means if they're not listed here, then they're not assessable for taxes. Agricultural personal property, commercial personal property, all equipment, furniture, so forth, all outdoor, well drilling, unlicensed commercial vehicles, industrial personal property, all machinery and equipment, personal property on mining companies, for taxes levied before 2003, residential personal property, utility property, electrical transmission, oil wells, inventories, gas wells, oil or gas fields, gas storage, transmission lines. But that's all that is, right? 3, the classification of assessable personal property are described as follows. And in 3, nowhere did it describe residential personal property except for taxes levied before 2003. Well, it's after 2003. So they wouldn't be able to level any taxes against you, right? It's not assessable. And it's a matter of going from 401 residential to 451 residential. And the way you find out is put in the damn form and see what they say. All right, but we got to get the owner's name right, get your particular name right, claim it as a DBA. Right, you have to claim this as a DBA. And it's just going to be your name then, and say, do the DBA, say you're the owner. And so that's what the lady in Wisconsin has done, right? She's claimed the DBA, so she could fill this out now and say she's the owner. Now I want to change it over to a better classification for her. Okay, I may have one more little thing, but we're just about done. Hang on. Okay, so what to try next? Well, I'm going to do this. I'm going to put in a notice of intention to file claim in the Court of Claims, the United States of America, ex-rel. I guess it will be me. State of Michigan. Oh, need to put the word "and" behind these. State of Michigan and 34th Circuit Court and 72nd Judicial District Court. That's what they told me on the reason they didn't put the state of Michigan on my claim was because I put state of Michigan and then 30 and Department of Treasury on the second line, and they thought that I just meant the state of Michigan Department of Treasury. If I had said state of Michigan and Department of Treasury, well, that would have been different. So the jots and tittles, right, need to put the word "and" because at the end of the day, I want the state of Michigan to be the defendant, right? So and the 31st Circuit Court and the 72nd Judicial Circuit Court. Claim deprivation of rights under color of law in violation of laws of the United States, resulting in the false imprisonment of Michigan resident William Jeffrey Whitmore. The Court of Claims has jurisdiction in imprisonment. Constitutional things, it has jurisdiction. Everything the state could do wrong. Here, it's called the Court of Claims. It doesn't need to be called the Court of Claims. That's its jurisdiction. So find yours. In Arizona, it turns out you're supposed to get a special form from the frickin' Attorney General. Hopefully Bobby has one here next week and I'll show it to you, right? But if you didn't know that, you wouldn't be filling out the right form. So they're trying to hide the remedy, but it has something to do with the Court of Claims, is my belief. Okay, claimant demands Williams' immediate release and relief. And that would be me, I guess. I was trying to send this to his family, but I haven't heard back, and it's like, I'll put it in. I don't need anybody to do it for me. Now that I understand how to do it, I'll just do it myself. So I swear, I truly believe the state of Michigan is negligent in its fiduciary duties to one of the people of the state of Michigan for allowing his false imprisonment and claim it the duty of said state to provide his relief from simulated legal processes conducted in Port Huron, St. Clair County, Michigan, in the state of Michigan's 31st Circuit Court and 72nd District Court for alleged charges filed on 31/17 by Judicial Officer West Michael. And most of that came off of whatever blah blah they were using to say he had done something wrong. William Jeffrey Whitmore, I don't want to call it a complaint because they don't do it right, so it's really not a complaint. It's just words on paper pretending to be a complaint. William Jeffrey Whitmore, resident of Michigan, is unlawfully imprisoned as a result of his victimization by these unauthorized legal processes, falsely prosecuted in the jurisdiction of an improper venue. What does all that mean? Well, the cases with these numbers were prosecuted by individuals using a false identification in an improper venue, using an unauthorized pleading, and impersonating court officers. Their actions are a violation of MCL 752.17c, 18 U.S.C. 242, the Constitution of the United States, the penal laws, the common law, and law of God in the kitchen sink. The style of identification of the prosecutors is not their full legal name, as defined in Title VI of the United States Code, specifically 6 CFR 37.3. The style of identification used is not the style authorized to practice in Michigan as found in the roll of attorney got by the Supreme Court clerk. This roll of attorney only enrolls individuals using their full legal name, and the use of any other style by an attorney is evidence that the proceedings are not conducted in the proper venue to prosecute Michigan laws. They can practice in Michigan in their full legal name. If that's where they're at using that name, you're in the proper venue for them to prosecute a Michigan law. Otherwise, it's the improper venue. In Michigan, they have to use the name on the roll of attorneys. And they're not, so apparently you're not in Michigan. Hey, just like that property. It didn't say it was in Michigan either. It must be, that property card must be in the improper venue. See how they do? The style of identification of the defendant does not comply with 6 CFR 37.3. Not only is the prosecutor wrong, so is the defendant. Whitmore. William Jeffrey is an improper identification for William Jeffrey Whitmore. It is an unlawful conversion of William Jeffrey Whitmore's identification used to conceal his captor's crimes against him and is identity theft. You know, you don't have to put up with any fucking shit they say. Just tell them the way it is. Plaintiff state of Michigan has no legal standing. It is not the identification of the state of Michigan. And I pointed out in the first Constitution of Michigan, 1835, in the preamble, it says the style shall be the state of Michigan. Well, the state of Michigan is not the state of Michigan. County of St. Clair, where alleged crime occurred, is not a venue of the state of Michigan. Right? It would be St. Clair County, not County of St. Clair. They can't both be an administrative arm of the state. One is, and one is simulating. And the County of St. Clair is the one simulating. It's also one that has the CAFR account in its name. And like in Kent County, the CAFR account, right? All the assets. So the net, if everything was paid off, is at least $500 million. 500 million, right? Or almost 600 million. But I mean, it could be a lot more than that. I just know that that's the amount it says on one particular line, and that's good enough for me. If they were to pay all their taxes, they'd have $500 million left over, which means they could give that back to all the taxpayers. You paid us too much. Anyways, officer of the court, Joshua Paul Rubin, defense attorney, failed to provide adequate defense, legal advice, or report these crimes. His actions are a misprision of felony violating 18 U.S.C. 004. Any legal pleading, motion, or other instrument upon which is found the improper identifications for the plaintiff, prosecuting officials, defendant, is evidence of an unauthorized process and impersonation of public officers, violating Michigan compiled law, MCL 752-17C, and a contempt of the Supreme Court. Claimant asked for emergency injunctive relief on behalf of William Jeffrey Whitmore, that he be immediately set at his liberty, and for the prosecution of the state of Michigan agents that unjustly imprisoned him. I haven't sent it yet, thankfully. I declare the statements above to be true to the best of my information, knowledge, and belief. I'm going to sign it before a notary at the bank, mail it like I did the last one, certified mail, and send it to the Court of Claims. Because the Court of Claims has jurisdiction over habeas corpus, and the way that they can get involved in habeas corpus is if they're made aware that there's a case that requires it. Well, my filing a notice of claim means I'm going to make them aware that there's a case needing them to do something about it. I'm not hoping to go to court. I'm hoping they issue an injunctive relief and let the dude out of jail. So yeah, down to the bank and get this signed and get it in the mail. And we'll see if that does something. Okay, well, that's what I'm doing. How about you? Right? If you don't have time to do anything and can support me, I'll do it. Right? But you can see the kinds of things I'm doing. I'm trying to get them to admit you can't use any name for me other than my full legal name. I'm not going to allow it. It's not what we're doing. Right? And I have one more thing I needed to point out. It has to do with the gold fringe flag. Hang on just a second. We're almost done. Okay. If you've never looked or noticed before, pretty much anywhere you look in any courtroom or any church, lots of other rooms, you find a flag with gold fringe on it. And, well, it's an Army flag. The Army's the one that has gold fringe on it. Just look at a color guard. Army guy's carrying the flag with a gold fringe. It's an Army flag. And so we've been trying to make that a point in the idea of the venue. See, if that flag is in the courtroom, then it's a military venue. You're in a military tribunal of some kind. Now, that could be because we're under some kind of military rule that's been going on since 1863 when they declared martial law, and it's never been rescinded. So that would be a reason to be under military rule. But if you are, well, the rules are different, and you need to know it ahead of time. But, however, if it's there, are you supposed to be there? Right? Where's the state court? How can they be trying me for a state crime in a court that isn't a state court? Wasn't established under the Constitution, unless you're going to tell me that we're under some kind of military rule. If not, well, then this is the improper venue for the hearing. Blah, 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 blah. Well, Bobby in Arizona made a point of that to somebody in the military. I don't know if it was the provost or the CID, who referred him to something, who referred him to a blah, blah. They gave him a little blurb out of something that U.S. Attorney General said back in 1925. The fringe does not appear to be regarded as an integral part of the flag, and its presence cannot be said to constitute an unauthorized addition to the design prescribed by statute. You know, some blurb like that came out of this thing written by an attorney general back in 1925. So it's 34 USOP ATTY General 483. If you were to Google that, and we'll just read what the attorney general had to say. Anyways, Bob had brought up the fact, he showed him pictures. He said, here's a military courtroom and here's a civilian courtroom. Why do they both look the same, and why do they both have a gold fringe flag in it? And they're trying to make it, like there's no big deal. But because of this little blurb that comes out of this letter, opinion written by the Attorney General, in which he said, I am in receipt of a letter from the late President Harding, dated February 15th, 1923, requesting from my predecessor then in office an opinion defining precisely what is the national flag of the United States and what official action is proper in order to preserve the flag from desecration. Accompanying this letter is a petition from the officers of the Military Order of the Loyal Legion, I believe those would be veterans, requesting the President to obtain such an opinion. From the correspondence attached to the letter, President Harding above mentioned, it would seem that doubts have been expressed in some quarters as to the propriety of attaching a fringe of yellow silk to the colors and standards used by troops in the field. Okay, so he's addressing something to do with, a military flag. The use of such fringe is prescribed in current Army Regulation 260-10. It's circular dated March 28, 1924. The Adjutant General of the Army thus refers to the matter of the fringe. For a number of years, there has been prescribed in Army regulations a knotted fringe of yellow silk on the national standards of mounted regiments and on the national colors of unmounted regiments. The War Department, however, knows of no law which requires or prohibits the placing of a fringe on the flag of the United States. No act of Congress or executive order has been found bearing on the question. The flag manufacturer, a fringe is not considered to be part of the flag, and it is without heraldic significance. In the common use of the word, it is a fringe and not a border. Ancient custom sanctions the use of fringe on regimental colors and standards, but there seems to be no good reason or precedence for its use on other flags. So ancient custom sanctions the use of a fringe on the regimental colors and standards, but there seems to be no good reason or precedent for its use on other flags. With these conclusions, the Adjutant General and I am inclined to agree. The fringe does not appear to be regarded as an integral part of the flag, and its presence can not be said to constitute an unauthorized addition to the design prescribed by statute. An external fringe is to be distinguished from letters, words, emblematic designs printed or superimposed on the body of the flag itself. Under the law, such additions might be open to objection as unauthorized, but the same is not necessarily true of the fringe. The presence, therefore, of a fringe on military colors and standards, on military colors and standards, does not violate any existing act of Congress. Its use or disuse is a matter of practical policy to be determined in the absence of a statute by the Commander-in-Chief. If a fringe is used, its color and size are matters of detail which may be determined by the same authority. In the present state of law, I see no reason for supposing that the paragraphs of the Army regulations above mentioned are ultra vires, or that the statute is imperatively requires the removal of fringes from all standards and colors. Conversely, if it should be decided by the Commander-in-Chief that the removal of fringes is desirable, there is nothing in the law which is imperatively requires their retention. So they can be taken off. But they're talking about a military flag. Commander-in-Chief, not talking about the president and his military role as Commander-in-Chief. So that little blurb they pull out, when you see something like this, is coming out of this act from 34 U.S. OP. All right, so it must be the opinion of the Attorney General, 483. Saying that on a military flag, you can have a gold fringe. But it didn't say you could have a gold fringe on a civilian flag. So where did they say they could? Right? It never has happened. And in the current regulation, 840-10, right? Because you could use this in a court case. Go get 840-10. Take it in and go to, let's see what page right here. Chapter 2, Flag of the United States. The flag of the United States is the symbol of our nation. Size and occasions for display. In 2-3, the national flags listed below are for outdoor display. All of these here. Got the post flag and the field flag and the storm flag, boat flag, ensign, Union Jack. National flags listed below are for indoor display and for use in ceremonies and parades. For these purposes, the flag of the United States will be of rayon, band, or cloth of heavyweight nylon, trimmed on 3 sides with gold and yellow fringe 1.5 inches wide. Okay, so we got a 4 foot by 5'6" size, and we got a 3 foot by 4. This size flag will be displayed with the Army field flag, distinguished flags, organization colors, and institutional flags of the same size. It will be displayed within offices listed in C below, where no other positional or organizational flags are authorized. And one of those was military courtrooms. Other than that, Army, military officers, organizations of battalion size, yada, yada, yada. They're all military. 2-7 says use and display by civilians. Use and display of the U.S. flag by civilians, civilian groups, and organizations are governed by 36 U.S.C. 173. If you read that, it takes you to 4 U.S.C. whatever it is, that shows you the flag that you saw when you were in school with no fringe on it. Doesn't make any reference to a gold fringe flag. All that to say, if there's a gold fringe, it's a military courtroom, and you should tell them so, that you know the difference. And it's an improper venue because you're a civilian, unless we're under military rule, and then the judge has a duty to enforce the federal law, and the guy who's not using his full legal name is depriving you of your rights under color of law in violation of 18 U.S.C. United States Code 242. Right? And you look for the judge to protect you from the belligerents. So, judge, are you going to enforce the federal law, or is that flag just a war trophy and you're an insurgent? Right? Are you part of the rebellion? Okay, enough of that stuff. You all have a great day. If you can donate, please do. RobRyder@AOL.com would be for PayPal, ROBBRYDER@AOL.com. or the address is at the beginning. See you. Bye.